Welcome to Law Awareness Weeks at CDC 2025. This webinar is part of Law Awareness Weeks at CDC 2025. It is a collaboration between Pro Bono SG, the 5 Community Development Councils, National University of Singapore Faculty of Law, Singapore University of Social Sciences School of Law, Singapore Management University School of Law, the Singapore Corporate Council Association Pro Bono Chapter, and the Singapore Association of Social Workers supported by the People's Association. I'm Karishma Galliara, and I'm your host for this webinar. Today's webinar is Marriage and Divorce, Understanding Your Rights Under Civil Law. Please note that today's discussion is not intended to substitute any form of professional legal advice. If you require specific legal advice, please consult a lawyer. With that, I would like to introduce our panelists for today's webinar, Mr. Teong Liang and Ms. Ming Zhen. Our legal expert today is Mr. Teong Liang, founder and director at TL Yap Law Chambers LLC. Teong Liang is a highly accredited family law practitioner in practice for over 30 years. His boutique law firm was set up in 2002, offering specialized legal services in family law practice, including disputes involving relocation and child abduction. Teong Liang is the chairperson of the Family Law and Family Rights section of Law Asia. He also sits on the panel of child representatives by the Family Justice Courts. Supporting us in our discussion is Ms. Ming Zhen, currently the Associate Director, Strategic Development of Family Services for Methodist Welfare Services, MWS, where they take on cases and support couples and families with marital and family counseling, including discernment counseling, divorce counseling, and phone and online counseling. She started out as a preschool educator, but her interest in children led her on to taking on community child protection work. She is a child-centric social worker and a family therapist by training. Teong Liang and Ming Zhen, thank you for joining us today.
Thank you.
Let me start by saying that marriage and divorce are more than just legal terms. They are deeply personal journeys, and while we all hope for the best, it is important to be aware of our rights, mindful of our duties, and prepare ourselves as best as we can in the event of a breakdown. Our goal today is to talk about marital rights, discuss the therapeutic justice approach in divorce proceedings, and demystify some of the key considerations in a divorce, such as children's welfare, maintenance, and asset division. With that in mind, we will try to address the following questions. 1. What is the matrimonial law in Singapore for civil marriages? 2. Do I qualify for divorce in Singapore? 3. On what grounds can I seek divorce? 4. What does the divorce process look like? And 5. What factors do I need to consider? We will deal with the last 2 questions together in the spirit of the therapeutic justice model's holistic framework. I'd like to remind our audience that we will be addressing all these aspects under civil law. There is a separate webinar for marriage and divorce under Sharia law, which will be held on 29 September from 7:30 to 9 p.m. With that, let's start with our first topic. What is the matrimonial law in Singapore for civil marriages? Now, to lend a brief context, the Women's Charter is the key legislation regulating civil marriages between non-Muslim couples, and it provides the legal framework for marital rights and duties, as well as the dissolution of marriage. It applies generally to all persons in Singapore and those domiciled in Singapore. Of course, it is important for the marriage to be registered, whether at ROM or overseas. With that bit of background, let us turn to the rights and duties of spouses under the Women's Charter. Teong Liang, can you briefly tell us about the marital rights and duties of spouses?
Yes, indeed. So, as you mentioned, that the Women's Charter is the primary legislation, and under the Women's Charter, parties are mutually bound to safeguard the interests of the marriage, as well as to care and provide for the children. So that's the fundamental approach, right, of the Women's Charter. But linked to this, you have other aspects, for example, of maintenance, child custody, care and control. And the idea really at the end of the day is to look at what is in the best interest of the children in dealing with these rights and obligations. So for maintenance for the children, one of the obligations is for parents to have to maintain their children, not necessarily in equal terms. A lot will depend on the financial capabilities of each of the parent.
See. So does that mean that one can apply for maintenance without filing for divorce?
Indeed, you can. You don't have to have a prerequisite of having to start divorce proceedings before commencing any application. So you may have a marriage in which maybe the husband has not been maintaining the child or children. Mom can actually then apply for maintenance even without the divorce.
I see. And I was reading in a recent Straits Times article that Singapore courts have seen 500 over personal protection order applications in early 2025 after the definition of family violence was expanded. Can you tell us a little bit about that?
Yes, I can. In January of 2025, the definition of family violence was expanded to include emotional and psychological abuse. And you have physical abuse as well as sexual abuse. So being the definition has increased, right? Naturally, you would see more applications, a lot of harassment, coercive control cases, which are coming before the courts.
Right.
Yeah.
It's probably a much needed legislative amendment then.
It is. I think in other jurisdictions, legislation has also changed because society has changed. The family dynamics have also changed.
True. I'd like to inform our audience here that a separate webinar on family violence will be held on 23rd October from 7:30 to 9 p.m. So in case you need more details on that topic, you can check out that webinar. Ming, what kind of support options do spouses have when their married life is not going as expected, or there's a sense that the marriage is breaking down?
Thank you for asking that question. I think to start off, no marriages is perfect. There's no marriage that goes on well perpetually with no issue at all, right? So I think the good news is help is available. MSF has actually started funding free counseling service for families in Singapore. So long there is one Singaporean or one permanent resident in the household, they are able to actually get free counseling service from 11 centers around Singapore. So the program is actually called Strengthening Families Program at Family Service Center, or FAM at FSC in short. And what we actually provide is mainly free marital counseling, parenting counseling, as well as any type of parenting and family counseling. So the purpose of this free counseling is to ensure that we strengthen families in Singapore. Yeah, and even if let's say there's small issues that are happening within communications of couple, for example, and they are not able to agree on certain important topic, right? Like for example, their children welfare within the marriage, it's actually possible to seek help from this service. Yeah, and on top of that, counselors are also trained in discernment counseling. Yeah, during event when individuals might be contemplating whether they should proceed with divorce or not. Yeah, they can seek help from a counselor and discuss their options. Yeah, and for discernment counseling is a trained and specialized counseling approach where we actually work with the client for them to actually come to a decision within short number of sessions, like about 5 sessions. So 3 points of possible decision. They can be thinking of staying in the marriage and working on the marriage with counselors or with other form of support, or they might want to proceed with divorce. But before they actually approach for divorce, of course, they should also discuss the option and how approaching divorce could have an effect on the spouse as well as the children in the family. And the other option is whether jumping into divorce is too quickly, so things can remain status quo for a period of time to actually assess how situation is and can be before they then make a decision subsequently or later on. Yeah, and on top of that, FAM at FSC also offer co-parenting program where if an individual has decided that they want to go for divorce, this is a mandated counseling or consultation session with a counselor. So they can actually spend 1 to 3 sessions with a counselor to talk about potential effect of divorce on the children and focusing on the co-parenting concerns that they have, before they actually apply for divorce. This is a mandated step because they will have to go through this session before they can actually file for divorce, so long they have children below 21 years old.
I see.
Mm.
And Teong Liang, on the legal side, if someone wants to seek legal advice, of course you can approach a law firm in a private capacity. But what other options are there if somebody is looking similar to the free counseling options? Are there similar options on the legal side as well?
There are. So you have legal clinics, which are run by the Law Society of Singapore in conjunction with the Family Justice Courts. You also have other organizations, for example, the Singapore Association of Women Lawyers, who also run free legal clinics. Although in either of these, whoever registers for it has to pass a means test. So not just everyone would be able to subscribe and get free legal advice. It's really meant to have what we call access to justice.
Right.
And there will be a means test for that.
I see. Interesting. Thank you both. So that brings us to the next question. Am I eligible to apply for divorce in Singapore? Teong Liang, can you briefly take us through the eligibility criteria to file for divorce in Singapore?
That's a good question because the starting point is if you're married for less than 3 years, then you can't actually commence divorce proceedings in Singapore unless you're able to show exceptional hardship or exceptional depravity. So you need certain criteria in order to apply for divorce within the first 3 years of marriage, and you need the permission of the court to be able to do so. So that's in the Singapore context if you have Singaporeans domiciled in Singapore. However, if you have a situation where you have cross-border, cross-cultural marriages, so husband and wife may not be Singaporeans, they could have been married UK, Hong Kong, Australia, for example, or even the US, and then they come and live in Singapore, so they expatriate contracts or they come for work. If the marriage breaks down in Singapore, the family justice courts will have jurisdiction to hear it, but provided you satisfy the criteria of either parent, either husband or wife, would have been habitually resident in Singapore for a continuous period of 3 years.
I see. Okay. So the next question then is, what are the grounds? What is the reason for divorce? So basically, there's only one ground for divorce, which is irretrievable breakdown of marriage, which in turn can be based on any of the following facts. 1, adultery. 2, desertion of 2 years. 3, unreasonable behavior. 4, separation of 3 years if the spouse consents to divorce. 5, separation of 4 years if the spouse does not consent to divorce. And 6, mutual consent. The last ground has been in effect since July last year. Teong Liang, perhaps you can briefly take us through the first 5 facts and maybe talk to us a bit more on the last one, that is mutual consent. It sounds very simple just from reading it, but is it really as simple to file?
It could be, a lot depends. So let's just take it from adultery first. So adultery is a situation where a spouse has an affair outside of the marriage. So it's committed adultery as an affair, and you find it intolerable to live with your spouse. So that's adultery. What's the evidence required for that? It depends. Sometimes you get private investigators' reports. Sometimes you don't need that because with social media, with WhatsApp, with emails, with photographs, a lot of things come out sometimes better than what a PI would get, right? People are a bit loose and fast and fancy, right, with their social media posts. So sometimes that gets people into trouble. 2, desertion of 2 years, it's not a common fact that is relied on because that means there's abandonment of family for a continuous period of 2 years prior to the commencement of the divorce proceedings. And unreasonable behavior is another one of those more common ones. It could be what I call a multitude of sins, right? So it could be anything as to how you treat your spouse. It could be financials, how you treat the children. You could even involve sort of in-laws, right? So it's the whole gamut of things. maybe in isolation it may not be, but cumulatively it could amount to unreasonable behavior. And separation speaks for itself. So under the law of separation, you have 3 years with the consent of the other spouse. If not, it's 4 years of separation without the need of consent. But then the question is, what is separation? So the most obvious case of separation, it would be husband and wife living in 2 separate homes, 2 separate households. That's the clearest indicator of separation with an intention to put an end to the marriage. But not everyone, and the law does not expect everyone to have the ability to live in 2 homes. So you could be in the same, what you call under the same roof, but in separate bedrooms. As long as during the entire period of separation, whether it's 3 years or 4 years, you no longer live as husband and wife. And that actually means you don't end up going for dates. You don't have to celebrate your CNY, visit in-laws, for example. You don't go for holidays together as a couple. And you don't present yourself to the world at large as a married couple. So basically, you do live your own separate lives. Now, in July of 2024, the new law came in to add a 6th fact, which is divorce by mutual agreement. That is not intended to make divorce easy, right? So there's certain criteria for divorce by mutual agreement, or DMA as we call it. So one of the things is parties will have to agree as to what goes into the document as to why the marriage broke down. So firstly, there must be consent. So it's quite clear. The second part of the DMA, what's required when you file the divorce papers, is you have to set out the attempts made at counseling or reconciliation. It does not require parties to get into professional counseling, but it's just attempts to do so. The third area is why they think that continuing reconciliation counseling is not going to help parties any longer. So it may have come to a point where they've tried everything and it's come to an end and they can no longer salvage the marriage. And the other part of DMA, which is not mandatory, but it's something for parties to consider, is whether they can agree to the ancillary matters. Ancillary matters meaning custody, care, and control, child arrangements of access, maintenance, as well as division of assets. So ideally, if parties can agree to all this before they file, then you have an overall agreement.
You see. But what if a party agrees to the fact of divorce, but they are not able to reach agreement on all the ancillary matters? Can that still be part of DMA, or then it would not be part of DMA?
It will be part of DMA because DMA is the fact of the reason you're using to show that the marriage is broken down irretrievably.
I see.
So just as much as you could agree to unreasonable behavior, but not reach a settlement on the ancillary matters.
Right.
Or agree on separation 3 years or 4 years, but still not reach an agreement on the ancillary matters. The case could still proceed. The court can still grant the interim judgment based on the consent of the reason for the divorce.
Right. So actually, we already have questions rolling in from our very active audience. Thank you for your questions. So I see a common pattern in the questions. I'm going to club them together. Most of the questions, the audience wants to know that if one partner wants a divorce and the other partner does not want a divorce, then what happens?
Well, I think if you don't want a divorce, I think try and see if something can be worked out. A lot depends on the dynamics of the family, the reasons why one of the parties want a divorce and the other one does not want. So possible counseling, marriage counseling with Ming Chen can add on to that is one way. Sometimes it's a question of a state of denial, right? And maybe things have come too suddenly, unexpected. So it takes a bit of time to sort of register. Because divorce is actually a huge decision to make, right? So it's not easy, but it's something that I think parties can navigate. But ultimately, even if you have one spouse who doesn't want and the spouse who wants a divorce starts the divorce proceedings, then the question that arises is, will the other spouse want to contest it, which means deny that the marriage is broken down? But it also means that, you end up having a situation where even if you end up in trial for a court to decide whether you can prove that the marriage is broken down, even if you can't, the other spouse can't, it would have meant parties would have gone through the litigation process. There's probably a bit more acrimony. And at the end of the day, yes, while you may still be legally married, you still probably may not have a marriage.
True.
In reality.
True.
So that it is hard. It's not something that one can just decide easily. Yeah.
Yeah.
Especially when you have young children.
True. Very true. There's another question earlier when you were talking about separation. So somebody has asked a very interesting question that who mandates that the husband and wife don't present themselves as a couple? So if they decide to go out together for dinner, does that null the period?
It can, but that will arise if, for example, one of the spouses contests the fact that they've been separated. And this will only really link to 4 years of separation. Because 3 years of separation, you need consent.
Correct.
So you won't have that scenario arising. So there are cases which I've done before, very seldom, in which we filed for divorce on 4 years separation and the other spouse contested the fact of 4 years separation, which means then you have to get into the evidence, right, of how you all lived the lives during that period of separation.
I see. There's another interesting question. Sorry, that's our audience is really active, so the questions are really bombarding on my screen. This question is, what if the male spouse has suffered from emotional and financial abuse? So I think this probably goes back to the family violence aspect of it, or under unreasonable behavior. So I guess the question is it only available to women, or it also applies to men who have suffered? Yeah,
it applies to men also. Men are not excused, right, from suffering from emotional or psychological abuse, right? Or for that matter, physical abuse.
Yep. Right.
Yeah.
And we have also, just to add on, we have also seen a lot of these cases at Family Service Center or even FAM at FSC that we are actually providing the counseling service. So it's getting more and more common. And I think what Teong mentioned, I think to also highlight that there's also the misconception coming from a husband or father thinking that, if let's say they apply for divorce, they will be at the losing end because they might not be able to get, for example, the distribution of asset or maintenance, or even the care and custody to the children, right? But we are also seeing that actually a lot of times, if let's say evidence are submitted to court, correct me if I'm wrong, that actually even men can actually receive maintenance. They will also be granted access to their children and be the care parents to the children. And they can be involved with their children as much as possible. Yeah, so of course, I mean, this is also with the fact that they are able to also provide evidence in terms of their relationship with their children, and at the same time how much they are really contributing to the family currently at this point. Yeah, so I have worked with fathers who also managed to actually have half of the time with the children, and sometimes even more, given that they have shown that they are the one who have been caring for the children right from the start. Yeah.
Right. So basically, the takeaway is that the law does indeed treat everyone equally. It's not favored to any one gender.
Yes. Just for the point on maintenance for husbands, the law allows you to claim, but you, unlike wives, the husband needs to show that he's incapacitated. So it could be that, due to medical reasons, he's unable to work and earn an income. He will be able to make the application now for maintenance from the wife.
I see.
But generally, other than having to satisfy that criteria, husbands would not be in a position to claim. So the law has shifted some years back. I think it's what I call an incremental shift. It may move further down the road, but let's see. I think society also has to be ready for that, right?
True.
Yeah.
True.
And I think to highlight the other point, so personal protection order can be applied by husband as well, if let's say they have suffered abuse by the spouse. Yeah.
Okay. And Ming-Chen, earlier you were talking about the different kind of support programs that are available. Can you elaborate a bit more on the different types of counseling that are available to couples with marital issues? So you mentioned discernment counseling and some other forms. Can you tell us a little bit more about those?
I think to add on, so there's 11 FAM and FSC across Singapore. So we want to be as close as possible to the family we work with. Yeah. So going to MSF website or going to for example the MSF locator website, they will be able to key in the postal code and see which is the nearest FAM and FSC that is closer to the address that they live in. Yeah. So FAM and FSC offers free counseling for anyone in the family, so long there's a Singaporean or permanent resident. Yeah, but on top of that, there's also a list of subsidized counseling services that are available. So just need to search for NCSS subsidized counseling. Yeah, then of course, the private counseling services that are available for people who are able to afford it. Yeah, and currently there's also more and more options for online counseling for people who are keen to access it online because they can't travel down physically due to work hours or something. Yeah, and I think to also highlight that marital counseling is one option, right? And then of course on top of that, discernment counseling, where we actually help the person to process through their decision to want to apply for a divorce, and what could be some of the factors that are contributing to it, and what are some of the factors that can actually keep them staying in the marriage for longer. Yeah, and a lot of times people might also be thinking that for marital counseling, both parties must attend it together. Yeah, and I think that's also like a misconception, because if let's say one person is more ready than the other, it's actually okay for one person to start off with the counseling first. Yeah, and we do take in cases like that where individuals are coming in to say that their marital relationship or family relationship are already affected and they want to talk about it. And when they actually come forward and talk about it, we actually process, for example, the pattern of interaction, we process the communication, we process about the conflicts that are happening in details. So it doesn't mean that the marital relationship will not change or evolve if it's just one person going forward for counseling. So it's still possible for changes to happen if let's say one person start to also talk to a professional about the dynamic and what's going on in the marriage. And a lot of times we also see like the other spouse might be more ready to come in for counseling if let's say he or she is aware that the spouse is really going on for a while, right? And it's already, changes are already happening, efforts have been made, things are shifting a little bit. So they kind of like see that success and the changes, and that might also prompt them to want to actually join in subsequently after. Yeah.
Right. Understood. Thank you. Thank you for that helpful guidance. Now we move on to understand what does the divorce process look like. Now, Teong Liang, I understand the therapeutic justice model was launched on 21st October 2024. Would you like to give us some insight into this TJ model and what does the divorce process look like under it? So
Yes.
exactly how has it changed from what was in existence before?
Yes. So therapeutic justice was a concept that was introduced into the family law regime in 2020. So you're right, in October of last year, it's sort of moving to the next phase of the therapeutic justice. So they now call it the therapeutic justice model. The idea of this is really for parents to, and the lawyers, right, as part of what we call the ecosystem, to find long-lasting solutions moving forward, right? Whilst the reason for the breakdown of marriage, the parties will have a lot of angst, a lot of acrimony. They are encouraged to try and move away from that, because when you keep going back, right, it's hard to see the future. And so the idea of this therapeutic justice model is to have the support, and I'll come to what the support is in a while, of parties going through a divorce process to consider certain things, right, in the interest of the children, and looking at holistic solutions to the issues in the marriage. So, for example, even before you can commence divorce proceedings now, you would have to attend a mandatory co-parenting program. So that's a prerequisite. So that enables the spouse who wishes to engage and initiate divorce to have to attend that as a prerequisite to filing. And so that gives that party some insight into what are the things they would need to consider when there's going to be a divorce, particularly where children are concerned. So the approach of the courts is really to encourage co-parenting, because that is actually going to be in the interest of the children, as opposed, right, to using the children as a weapon, or what we call weaponize the child, right, against the other parent. So you would have heard of things like gatekeeping, preventing access, making it difficult for contact time between the child and the father, or in some instances, the child and the mother, if the father has care and control. So we're trying to move away from that and encourage parties to look in the broader picture. Now, once you have children below 21 years old, as Ming Chen mentioned, right, you go through the mandatory co-parenting program, and once divorce proceedings start, the courts will usually now schedule what is called a TJCC, which is a Therapeutic Justice Cooperative Conference. So that involves the husband and wife attending together with their legal advisors. There will be the mediation judge. There will also be a court family specialist who is a counselor working within the courts, right, to assist parties and speak to the parties to try and help them navigate arrangements for their children moving forward. So basically, you get free counseling, right, through the court system. Right? And after that counseling session, parties will continue with the mediation to try and reach settlement on children's arrangement. It would then lead into discussions on the finances of maintenance as well as division of assets. And all this is done even before parties end up in court in the dispute. So they try to get parties to agree as much as we can.
So you spoke of mediation as sort of being the first step before the actual proceedings commence, right? So typically, if the couple is fighting and there is a lot of bitterness, it seems almost counterintuitive to be cooperative or to be nice. So as a lawyer, what would be your advice to such couples in terms of the approach that they should take to mediation?
Yeah. So this will take time. It's not going to happen in your first few meetings with the client. It's really sharing with them if this is sort of the approach they wish to take, right? It's really sharing with the clients how would that approach benefit the children, right? Or how would it look like to the other parent, right? It's just trying to shift the mindset and the thought process, moving away from trying to punish the other parent, right? And weaponize the child against the other parent.
Right.
Yeah.
And you spoke of the mandatory co-parenting program. So there is a question that what is the function of this program for parents who are separated due to irreconcilable differences, but they may not file for divorce? So is it still a mandatory co-parenting program then, or then it's just voluntary?
This, in that case, if they don't have plans to go ahead and to file for divorce, actually it will be voluntary. Yeah, so it's actually still possible for them to approach any family FSC to actually talk about access issues, or for example, them wanting to actually interact more with their children and the spouse. Yeah, but I think the tricky part to that question is if they don't file for divorce and if they have no access to their child, there will be no court order in place in terms of forcing or getting the other parents to ensure that access happens. So it becomes the family issues for them to actually discuss and work out. So in that case, I would think that what Teong mentioned just now, the mediation will also be most useful. Yeah, if let's say they don't file for divorce, there's or there's no lawyer in place, whether they want to actually consider mediation to discuss how to work out some of these differences and issue. Because at the end of the day, it's about the children, right? I really like what Teong mentioned just now about how there might be the marriage, but if there's no quality of relationship within the marriage, that process will also affect the children and the individuals in the family. Yeah, and I think is to highlight that we have seen a lot of parents who don't want to go through divorce because they want to be together for the sake of the children. But research studies have also shown that conflicts within family affect children more, than the divorce process itself. So it's the conflict that actually matters. If there are constant conflict happening at home, that itself is challenging to the individual as well as the children. And we have seen cases of parents or individuals who are going through the divorce process, and the stress could really accumulate and drag on, amounting to like other mental health issues or either physical illness and issues as well. So the legal process can be stressful. At the same time, of course, the constant conflict, if they don't work out certain arrangement that is in agreement with each other, that itself is a stressful process.
Right. And there was a question here, but I've lost it. I do remember it though. You spoke about approaching FAM at FSC. So I think the question was, does the couple, or whether it's the mother or the father, do they need to be referred to FAM at FSC by someone, or can they self-approach?
They can actually call up the individual center. So there's 11 FAM at FSC across Singapore. It's possible to search the nearest one to their residential address. They don't need to be referred by anyone, because FAM at FSC serve voluntary client. Give you one example, right? So I have this father with a very young child, and they are already considering divorce. So from his perspective, the wife has actually proceeded to apply for divorce already, but he's not sure which stage is it in and how it's affecting him and the child. So he actually took the first step before the court made the referral. He actually approached FAM and FSC and say that he needed counseling for himself as well as for his child, because he's not sure whether how the child is adapting to the arrangement of not seeing the mother and living in separate houses, for example. So he wanted to open up the conversation of like the changes happening in the family. So sometimes we don't need to use the term divorce to explain to very young children, but it's to actually explain the process of like, daddy and mommy living apart and how it will affect them, and giving them the assurance that they will still get to see daddy and mommy on which days of the week, and when, how they can contact, for example, the daddy or the mommy if let's say the child misses them, for example. So really opening up conversation that the child might already be thinking, and how it directly affect the child because the child is going through that experience. So it depends at which point where family justice court will make the referral, because in some cases, the court might also actually issue mandate and meet recommendation to say that the children will have to actually go through certain divorce program. Especially if let's say the court has assessed that the impact of divorce is affecting the child. So there are actually group work program that we run in FAM and FSC, where we actually like talk through with the children about divorce matters, about how it affects them, opening up conversations about how they would like to spend time with their parents, and also getting other children to share how things have been in their family, so that they are aware that they are not alone, and they are not the only one whom parents are going through divorce. So that kind of setting can actually let the child feel safer to share, and also like hearing from other children can also help them to see other ways of coping, other ways of managing this problem that is happening at home.
Right. So just now we are talking a lot about counseling. So in that context, there is a question. So somebody has asked, can I directly process separation without any marriage counseling? I think what the person is trying to ask is, if there has been a separation, can they directly proceed to file for divorce, subject to meeting the timing requirement, or must they go through marital counseling?
Mm.
And what is your advice?
Okay. Yeah. So thank you for asking that question. So, just to also highlight, no marital counseling is mandated. Yeah. The only thing that is mandated is if, let's say, parents have children below 21 years old and they want to proceed for divorce, then yes, they will have to attend a 1 to 3 session consultation or counseling session with a counselor to talk about co-parenting arrangement. Yeah, so that 1 to 3 session is really focusing on how divorce will affect the child and some of the living arrangement, caregiving arrangement discussion, and how financially this process might also affect them. Yeah, so this is the only mandated step if, let's say, there's children below 21 years old. Yeah, beyond that, there's no mandated counseling in any form if, let's say, individuals want to proceed on with divorce.
But in your experience, and this question's for you as well, Teong Liang, absent any mandated requirements, but is there a difference? Does counseling have a very visible difference in divorce proceedings between couples who have sought counseling and couples who have not?
I think there will be. So just to take an example, we shouldn't underestimate the impact of quarreling parents in the home, quarreling, shouting at each other in the presence of the children who hears things, sees things. So the idea really is that to keep the children isolated from being exposed, right, to quarrel, shouting, because the impact on them can be quite diverse. So, for example, and Ming Chen will obviously know this better than I do. It could be that the children blame themselves. They'll see that, oh, my mom and dad are quarreling because of me. Right? And once they begin to process that, it's incredibly difficult as they grow up, right? Because it will impact their lives probably as teenagers and in their adulthood and in their adult lives. Counseling, I think, will help because it probably shares and educates the parents as to how to communicate with the children. No one teaches anybody communication, right? As a starting point, right? And there are many ways to communicate. And part of communication is listening. Right. It's not who speaks louder or who has the last word. And how you communicate with children at different ages also be different. And some nobody went through parenting school, right? It's sort of on the job training. Right. So that's something to think about, really to protect your children from the fallout of marriage.
Yeah, right. Really, thank you, Teong Liang, for also mentioning that. I think, of course, no counselor can guarantee that upon going through counseling, the marriage will be intact or they will be able to stay in the marriage. So the purpose or the objective or the outcome of the counseling might not be to stay in the marriage, but it could possibly be how could they be better co-parent? How could they be better, for example, add spouse to each other when they need to communicate issues, right? Because I think even in our previous sessions, we were saying that so long they have children, actually their relationship and the family tie stays for life, right? So imagine the child growing up, getting married, having children, they will still have to see each other and kind of communicate and interact with each other. So how can they form a better relationship and start this conversation as early as possible in terms of like managing out issues, managing out problems, so that emotionally and psychologically it's also easier for them when they actually move forward with the divorce eventually, right? So I can't guarantee the percentage, but we have seen a good number of cases where they were contemplating divorce, but upon coming in for counseling, they actually retain the decision and they actually try to work on the marriage and find other ways to manage their differences and issues. Yeah, so we have seen couples like that who decided to stay together and able to actually have at least slightly better relationship, slightly better communication. Yeah, and we have have also seen like parents who actually come in to also process the grief of how the impending divorce or the thought of divorce is actually affecting them, because sometimes we don't realize how it might also affect other aspects of our life, like extended family. How do they address this with their extended family? How do they actually address this to their friends, or even employment when they start to take leave to actually attend court sessions, right? So all these issues are compounded in that sense. So it's not just the marital itself, but it's really how this issue is affecting their emotional bandwidth, their emotional capacity to also be there, be present for the children while the children also experience the divorce. So how could we help them to be better parent when they are going through something so difficult, so that they are able to actually still function well as an individual and take care of their children well, even though they are going through these legal battles? Because honestly speaking, no one wants to go through something that is so difficult. Yeah.
And does it also make a difference, Teong Liang, for couples who have genuinely given counseling a shot, even if they've decided to divorce? Like Ming said, it may not necessarily be to keep them in the marriage, but hopefully to make the divorce less acrimonious. Does this also help with selecting the track, whether you're contesting the divorce or fighting about ancillary matters? Do you think it helps to simplify the actual divorce proceedings for couples who have genuinely attempted to seek counseling?
Yes, good question. The answer to that is yes. So if you've attended counseling, it gives them maybe a different perspective. Right? And if they're able to resolve the reasons for the divorce, which actually more often than not is resolved, because there's really no point fighting over the reasons for the divorce.
Right.
In court. It's going to be costly, and ultimately, it's just the judge will decide who's to blame for the breakdown of the marriage. Right? So it's not really worth the time and the effort, really, to litigate that, spend a lot of time, effort, and money to litigate the reasons for the divorce, or at least the breakdown of the marriage. But if parties, through counseling and through a different perspective, can look at trying to resolve the arrangements for the children, the maintenance and division of assets, that can be done actually before proceedings have started. And if you can reach that agreement, then it goes and it's found on what we call the full simplified track.
Okay.
So everything's agreed.
Okay.
So the minute you file, you have a consent order of court, which sets out all the terms of settlement. How you get to the arrangement before filing, there are many ways to do that. Sometimes couples are able to have that discussion amongst themselves. They agree, and then they see one set of lawyers or two different lawyers to get their advice and then draft out the document. Sometimes parties can get legal advice, and then you appoint or jointly appoint a mediator who then facilitate the discussions and hopefully help parties reach a settlement of the ancillary matters. So if you are able to get to the simplified track, I think it augurs well, because then there's no litigation involved in that process.
Right. Right.
But if you can't, then becomes what we call the partial simplified. As you mentioned earlier, the reason for the divorce is agreed, but the ancillaries may not be.
I see.
But we still have that process, if you have young children, of mediation to try and get parties hopefully to reach a settlement, or at least a partial settlement on the ancillary matters.
Right. Okay. So speaking of ancillary matters, we have been talking already actually about children's matters indirectly. So let's start with that first. So children's matters are aspects of custody, care and control, access, that is visitation, and maintenance. So Ming, as a social service professional, your role is probably at the forefront in terms of helping couples with their thought process, how they should be framing their thinking. So can you walk us through what should the thought process be? You already spoke a bit about it in terms of parents having to put children first instead of putting themselves first. But can you elaborate a bit more on what should the ideal thought process be when it comes to dealing with children's matters, and especially if there are differences in parenting styles, how does one resolve that?
I think parenting itself is a huge topic, right? So Teong mentioned that no parents go through parenting school. So that process itself can be very challenging. What more if, let's say, they have gone through divorce and they have to actually handle co-parenting with an ex-spouse. Yeah, and it's really understandable that there might still be some negative feelings, like for example anger, denial, resentment towards the other person, right? And I mean, nobody go through marriage wanting to go through divorce, so it's really a painful process that we can understand. Yeah. But when we actually talk about how asset or even like maintenance and access to the children, is really also sometimes understanding how the changes in the family dynamic has affected the child, right? So for example, right, sometimes when children have to actually move between two houses within the week, there might be times where things are like missed out or forgotten, and the child has to go to school without this particular homework that has been done, or without the soccer books for the CCA, for example, right? And how this process might also be affecting the child socially and emotionally, right? When the child is also growing up with enough challenges in school or socially. Yeah, and to also highlight how children sometimes might also be able to be aware and attuned to how the individual parent might be feeling and thinking. And sometimes even, for example, we see a lot of youth, they would have their own struggle and challenges, but knowing that their parents are going through a hard and difficult time, they might not want to sound out and burden their parents more, which then will lead to situation like what Teong mentioned. They might blame themselves, right? They might feel that they are taking up too much energy and time from their parents. And they try not to do that and manage their issues on their own. But being a teenager today is really getting a lot harder, right? We are talking about beyond academic issues, social, emotional issues that are happening out there. So can you imagine if, let's say, a teenager is facing this issue at home and they don't feel safe enough to talk to anyone about it, right? So sometimes, even like approaching counselors, we were not forced for the parents to have to communicate with each other if they don't feel safe enough. But it's really to look out for their child, what might be some of the changes and symptoms and signs that are happening, and whether there are other support systems that the family can bring in. For example, is there an auntie or uncle that they can actually bring in to help to keep a lookout for the child as well when they are in the midst of going through something so difficult on their own, and whether there's a channel where the child can ask questions, right? So for example, I saw this very young child and he asked this very deep question, right? After we start to open up the conversation of divorce, and he actually asked the father, because we talk about what the arrangement is like, and he said, Daddy, will you stop loving me one day because you stopped loving mommy? Yeah, so imagine the kind of like questions that the child must have in mind, right? So eventually how this will also affect the child growing up process, their thoughts and ideas about family and marriages. Yeah, so having healthy conversation and knowing that at the end of the day, even if the couple were to, like, for example, lose out a little bit at this moment, what do they stand to gain or win for the children and for each other in the longer run, right? So I think we are also constantly very inspired by clients who are able to come back to share. There's this one particular case where the mother actually talked about how instead of going into the details of maintenance, like for example, I need to make sure that like every month you pay me exactly like this amount of money. If I don't get it, I will go back to the court to ask for it. Instead of that, the mother and the father is able to work out an arrangement to say that like, okay, the day-to-day expenses, the mom can pay for it. But for the bigger expenses, the father is willing to be the one to actually pay for it. So this actually helps them to build like better relationship, and it helps them to have lesser stress instead of calculating everything at the end of the day. But it's to be able to know that they have the support of each other. They can kind of work out this kind of discussion. Yeah, and to a huge extent, it's also easier for them psychologically and mentally that they don't need to kind of like focus on the details of the expenses. Yeah, so be able to come to this stage, I suppose, is also not easy. But the mother find it really helpful that the father has initiated such an arrangement. Yeah, and they are able to actually focus on co-parenting well. So, for example, the child was hospitalized, so the father was prepared to actually pay for the hospital bill, but at the same time, they were able to be present to care for the child. Yeah, so it's really to let go of the details that would actually bug them in the day-to-day and to focus on the bigger picture of what works best for the child and for both of them.
Right.
Yeah.
Right. That's very helpful to know. So that's about the thought process parents should have. Teong, absent cooperation or mutual agreement, what are the factors that a court would consider when making an order on children's matters?
Yeah. So the overarching approach of the courts and the law is what is in the best interest of the children. Obviously, mom and dad will have different perspectives of what's in the best interest of the children. So you can imagine that the court, right? I don't envy the judges who have to decide that, which is why if I take an example of, when the child is 6 years old, come July, you have to apply for school. Then the question is, mom and dad may disagree on the school, right? They could be within 1 kilometer, but you're going to do 2 different schools. Right? If you think through it, right, how is a judge or a court going to decide which school is better, right? But the choice of which school is a choice which mom and dad will have to make for their child, right? So it's not about because you want school A, I want school B, right? And when we deal with children's issues, I think it's important to also understand some of the concepts. One is custody, the other one is care and control, and the third is access. So custody is about the major decisions concerning your children, health, education, and religion being the main ones. And usually in a divorce process, the courts will incline towards joint custody, which is actually the co-parenting.
Right.
So if you think about it, in an intact family, functioning family is actually joint custody.
Right.
Mom and dad would discuss, they can agree to disagree, but they will have that discussion. So no one parent will have a superior right to make those major decisions for their child. Care and control is with which parent the children will live with post-divorce. So it's usually either mom, sole care and control, or dad, sole care and control. There's also an approach of shared care and control. But shared care and control does not mean the splitting the time equally. That's not what the law is about. It's about what's the best arrangement. It also, in a shared care and control situation, it requires mom and dad to be highly cooperative.
Right.
If not, you can imagine if they keep disagreeing, the child will be left in limbo.
Correct.
Right? No school, who's going to prepare the test on a Thursday or a Monday, things like that.
Yeah.
So it's not just, okay, let's get equal time just for the sake of equal time, right? So it's whatever arrangements you come up with is how would this work given the routines of their own children,
Right.
right? And nowadays children are very busy with tuition and school and academic.
Right.
Yeah.
Right. So in context of care and control, which, as you said, is a day-to-day, who the child lives with. So there's a question we have, and it is if the couple is one Singaporean and one foreigner who is on LTVP, and they undergo divorce, does the foreigner wife have a chance of asking for the child's CNC care and control, or will she be deported?
Not necessarily so. Obviously, LTVP has its restrictions in the sense that obviously post-divorce, right, the ability to remain in Singapore could come into play. So really, at the end of the day, if you have such a situation, it is really about what your plans are moving forward into the future. So you have one Singaporean and one non-Singaporean. Sometimes the spouse may want to go back and return home because they may not have a base here in Singapore. So those are also the considerations that have to be taken into account to look at what will be the ideal long-term plan for the child, which may mean also change of school, things like that, right? But sometimes you can have a child in school and then you sort of tag on, right, to the child's student. Right? So there are different ways of looking at things. But then again, from the dad's perspective, right? If the child's dependent or the mom is dependent, right? When they first get married, etc. It is really, is it in the child's interest to have mom around?
Mm.
Right.
Right.
So there are a lot of components to think about. Yeah.
And turning to the other aspect of children's maintenance, what factors would the court take into account if the parents are not able to agree? How would the court decide?
Yes. So the starting point is to have a list of expenses per month as to what the children require. So that would include, school fees, tuition, enrichment classes, insurance premiums, health, medical, school books, the year-end stuff and all that. Once you have that list, hopefully parties can agree to what they require to maintain their child or children. What the courts then do is really to see what parents earn. So the apportionment is based on the income they earn. And that's usually looked at from the income tax notices of assessment.
Right.
And that's a fairer gauge because some may have bonuses, some may not have bonuses, as opposed to monthly salary. So if you know that's how the courts will look at it, then if we come back to trying to reach agreement, if you adopt the same approach, right, it's trying to reach that agreement which a court would have to decide anyway.
Right.
Right. And so looking at from that angle, that's how the party should look at it. So it's not, you earlier asked at the start of this session, right, what are the obligations, right? So the obligation is you have to maintain your children. But the obligation is not necessarily an equal obligation, because if mom earns more than dad, then mom is expected to contribute more. So in the proportion of their income.
Right. So it's interesting you say that, because we actually have a question on precisely that point, that there's a huge income, there's a huge disparity in the earning power. The wife earns more, and it seems the husband decides that he does not want to work post-divorce. Does the wife have to contribute more for the children's expenses?
Okay, so I think the problem in that question seems to suggest that the husband does not want to work, right? So the question is why?
Yeah.
And certainly I think the courts would not encourage somebody to just stop working so that I don't have to maintain my children. So if the husband, for example, has been working throughout and there's no reason why he cannot continue working, so there'll be a lot of questions asked as to why he's decided to stop working.
Right.
Yeah.
So basically, you cannot get out of that obligation just by choosing to not work.
Not with having to answer a lot of questions.
Right. Okay. So we also have another question where the couple is, and Ming-Chen, I think this is probably for you, where the couple is in the process of divorce and living apart, and they are fighting over who fetches their son from kindergarten, and there's no interim care and control order. So when the kindergarten asks the child who he wants to go with, the other parent, the non-chosen parent, felt the child was coerced. So what are your thoughts on this situation?
I think this is a really tricky and sensitive question, especially if the responsibility is put on the child by another adult, right? So usually in these kind of cases, we will actually advise for the less professional to intervene. It will be the best, because why I mentioned that is because imagine if the child is asked multiple times by multiple strangers, right? Like, who do you prefer to be with, right? It's not just stressful for the child, but it's also how this might affect the thought processes of the child, and also how the child might feel towards this whole situation of divorce that the parents is going through, right? Yeah, and what we usually advise is, especially if the application for divorce has already started, but there is no interim care and control, it's best if, let's say, this matter is, for example, brought back to the court, okay, for the court to actually work out an arrangement, or the parents themselves can go through like a mediation, or even like, for example, extended family and relative, to kind of like work out and discuss what is the best way to manage and care. Because in the midst of this, of course, what we can understand is the handover of the child is actually the most difficult part, because the individuals don't want to be seeing each other, right? Even during handover. So I've worked with parents who work on an arrangement to get, for example, the grandmother or, for example, a relative to be around at the point of handover, so that they don't have to like end up seeing each other and end up quarreling and having conflict, right? So that's one way. But what we will also say is that it is okay for individual parent to actually seek help from either social workers or counselor, because on top of FAM and FSC, sometimes if let's say the family issues is a little bit more complicated, especially if let's say there are like constant conflict and violence happening at home, family service center across Singapore also serve this group of client. Yeah, and usually if let's say individual parent were to actually like for example bring the child for counseling or bring the child for programs and services, we are able to actually support the child with the parent consent, right? But if let's say if we are trapped in between both set of parents, then that becomes tricky and difficult, because again, professionals shouldn't be citing one particular parent, especially not by confusing the child, right? So at the court, there are also trained counselors who, let's say if needed, they will be the one assigned to then talk to the children, to then assess and do what reports to understand, for example, the child interaction with individual parent, and how the child might also have a preferred arrangement, for example. Yeah, so the best way is not to intervene and kind of like help the child to make a decision or force the child to make a decision, especially if the child is not ready. And why I highlight that is also because we have seen children who, upon going through multiple different professionals who they seen as like strangers and adults, they started to build mistrust towards system, and they started to have to also feel adverse towards wanting to meet another new person. Yeah, so we want to actually keep this process as clean as possible. So only the people that is really necessary to interview and talk to the child about the child preferred arrangement should be talking about this aspect for the child as much as possible. Yeah, otherwise then of course it's really focusing on the child needs in general, right? Is the child needs met? For example, is the child struggling in school, having difficulty adjusting to this new living arrangement, which we can actually help the child to work out and also to work with the parents to work out. But we don't come in to ask the child, who do you prefer? Right, so that's the question that we want to avoid at the end of the day, but it's really focusing on what other needs is coming up for the child that we are able to support. Yeah.
There's a question come in which actually quite a few number of members of the audience seem to have the same question as to what are the effective interventions for supporting children showing signs of trauma as a result of high conflict divorces. And there's a related question which is almost counterintuitive. I lost it. I think the question was that what happens if the child does not want to go through counseling? How can FAM at FSC help in that case?
So thank you for that question. I think there's two parts, right? So one part is the if let's say the child has gone through high conflict parents related issue that could lead to some trauma related symptoms and signs, right? So there are actually various ways around it, but it really also depends on what works best for the child. So for example, there are expressive therapies approaches out there. Say for example, play therapy, art therapy, same play therapy work. So different kind of therapy approach comes out also because different child has interest in different aspect, right? And different kind of approach appeal to different group of people as well. So it really depends as well on what works best for the child. And I think on top of what works best is also dependent on how the child feels about the counselor, the environment, and at the time of the child receiving this therapy approach, is it really the best time for the child, right? So I have seen some cases where, for example, if the parents are really going through divorce at the point of time, the child is really in stress, and on top of that, there's other academic issues that are happening. That might not be the best time to actually force the child to see a counselor. Yeah, so it's also pacing it out with the child and waiting for the right time. Yeah, and there are also like online counseling or phone counseling for children. So Tinker Friend, by Singapore Children's Society, if I'm not wrong. They have been offering this service for a while. So children who feel ready, who maybe they are not ready to actually let the parents know that they want to seek help, they can actually call the hotline and talk to a professional. Yeah, so that is actually one possible platform. On top of that, actually we do have other ways to engage children and youth beyond just really counseling, right? Say, for example, get them to actually go for group work, to hear from other children whom parents have gone through divorce. At that place, they also meet with other friends. They start to opening up and share some of their own concerns upon hearing from others. So that's one aspect. And also for youth, there's a lot of youth outreach program, youth drop-in center, right? Where youth can actually attend these programs that generally just help them socially and emotionally. So once they open up and feel safer and more comfortable with the professional there, then it makes it easier for them to start sharing about other issues, for example, family-related issues like divorce, right? So we don't need to target the divorce issue upfront, right? Especially if the child is not ready at that point of time. It's really to look at what other kind of support system could be helpful, right? There are other cases where the child might feel helpful to just talk to the auntie or uncle about the experience, and then slowly, when the child starts to open up other conversations, then the uncle and auntie can refer them to a professional, for example. So it doesn't have to be at the point of time where the divorce is happening or where the issue is happening, then the child is forced to see a professional because the parent feel that it's the best. Yeah, we want to actually avoid that kind of situation. So it's really waiting for the child to be ready. And I can understand sometimes children who don't want to see a counselor, also because of their previous experience with counselor, for example, school counselor, or maybe they hear from their friends how counseling is like. Yeah, so if counseling is not the one way, we can also see whether there are peer support group, mentor for children. Yeah, and sometimes it's also seeing other professionals like psychologists or, for example, psychologists and other possible professional, right? Like social worker and psychologists. Yeah, so I think to add on, for more severe cases, if counseling doesn't work, there will also be, of course, psychological service. So, for example, KKH, as well as NUH, they have the child guardian clinic, right? So for parents who are concerned about how the children are going through this psychologically and mental health wise, are they coping well? Then that's also another platform. So if let's say they want to get subsidized psychological service, it's possible to go through the polyclinic route as well. So going to a polyclinic, the GP, to talk about how the child might be going through some difficulty and struggle, then getting their referral towards child guardian clinic to see a psychologist from there. Yeah.
Let's see. And Chonglang, there's a question asking that if the child is adopted and the end of the divorce, if both parents decide they don't want the child, I shouldn't be smiling at this question, but there's actually a question where they say that if the parents don't want the adopted child, how does the court decide who the child goes to?
I think the starting point is the child is adopted. They would have actually gotten an adoption order. So they would be the parents of the child. So you just can't abandon the child because you're getting a divorce, right? And the state is not going to look after the child for you, right? So the obligation of the parents will be to look after the child, even though it's adopted, right? Because you adopted, so it's an official order for adoption already.
Right. So I think we are running out of time. Let's move on to the next part, which is spousal maintenance and division of assets. I think in the interest of time, I'll club both. So Ming-Chen, starting with you, generally, what is the tendency of couples on these aspects of spousal maintenance and division of assets? And again, what should the ideal thought process be?
I think the biggest concern when we talk about this is fairness and equity, right? A lot of times individuals might be thinking what is fair for me or what is like equity across both of them, right? But honestly speaking, when we talk about maintenance, especially for children, right, there is no strict fairness. Yeah, so when we just talk about the day, 7 days in a week, right? So who care more for the child in terms of paying for a certain aspect of the child meal and all? all of these. So it's not possible to really go into that details in that manner. Yeah, and I think what we have experienced a lot is nowadays father might also feel that they might be missing out, so they try to fight harder, wanting to prove that they are caring for the child in this aspect, and they are trying to provide more evidence, right? Of course, that process is helpful for them to also advocate for what they have already been doing for the child, but it's also to highlight how the court takes in account a lot of factors like what Liang mentioned. Sometimes it's not like they advocate for certain things, they prove certain things will go the way it is, right? So it's also being able to see that like in longer run, at the end of the day, what would be best for the child again, yeah, and what's the best arrangement in terms of providing for the needs of the child in that regard. Yeah.
And Teong, from your perspective, I mean, what are the factors the court would consider in context of spousal maintenance or and division of assets?
Yes. So for spousal maintenance, maybe I'll start with what is the period you need to support your ex-spouse. So for spousal maintenance, it's either a monthly maintenance or a lump sum maintenance. So if it's monthly maintenance, it just means that the wife, generally wife, right, would come up with their list of expenses, look at what can be agreed. The court will take into account the earning income which the wife has. And spousal maintenance under the law is supplementary to division of assets.
Right.
Okay, so it's not in every case that you will get spousal maintenance plus division of assets.
I see.
So sometimes the court may not give spousal maintenance if you got a fairly large share of the assets. Right? That's why it's supplemental to the division of assets. Lump sum maintenance, it just means it's a one-time payment. Sometimes it can be done over a short period of time, but it means that you cannot then go and vary it, unlike a monthly maintenance.
Right.
So if it's monthly maintenance, the period of support, right, will be until the wife passes on or remarries. Whereas it's a lump sum, it's just a lump sum.
Right.
There's no variation to that. And when I say variation, one can vary it upwards or downwards depending on the party seeking variation to show a material change of circumstances. For division of assets, I think the starting point is the courts will divide all assets acquired during the marriage, which means it's what I call in three baskets, right? Anything in the joint names of husband and wife, anything in the name of the husband, and anything in the name of the wife. So joint assets could be joint bank accounts, it could be properties, generally the matrimonial home, which is in the joint names. Individual assets will be bank accounts, CPF monies, investments, stocks and shares, cars, jewelry, and it varies from case to case, couple to couple.
Right.
And the courts will look at the values of these, right, and add them all together. You get what we call the value of the pool of matrimonial assets.
I see.
Right? But when I talk value, where the matrimonial home or properties are concerned, it will be the current market value net off the outstanding mortgage loan.
I see.
Okay. And how do the courts then divide, right, the pool of assets? They will look at two components.
Right.
One, the direct financial contributions of each party towards the acquisition of the assets, which means who paid what towards the property, the down payment, the CPF monies, the mortgage, renovations to be considered direct financial contributions, for example. And the second component would be the indirect contributions, which actually has two parts to that. One is the indirect financial contributions, which is who's been paying for the family's expenses.
Right.
And the second element to the indirect contribution is what we call the non-financial contributions. So the non-financial contributions really relate to each party's role as husband, as wife, and as mom and as dad in the course of looking after the children, the marriage, things like that, and any sacrifices either of the parties would have done. Then the courts will look at the weightage between the direct financial contributions and the indirect contributions. So generally in the longer marriages with children, the weightage would more often than not be equal weightage.
I see.
So once you have that, what we call the structured approach, the courts would then look at dividing it in that form. And this structured approach applies to a situation where there's what we call a dual income marriage, right? So then the next question is what happens in a single income marriage? Right? So single income marriage, the law looks at what are the trends of past cases in which, you look at cases in which you have a similar length of marriage, similar number of children, and we look at that, and it's usually divided based on that.
Right.
But overlapping this is potentially there may be a question so what happens to gifts and inheritance, right? So under the law, gifts and inheritance are excluded from matrimonial assets,
Oh,
right? Unless it is a gift of a matrimonial home, right? Or is a gift or inheritance, but you then commingle it, right, with marital wealth. So it's sort of mixed up, right? And you don't ring fence it.
I see.
Then that becomes the challenge, right? Because you can't really demarcate which is marital wealth accumulated during the marriage,
Right.
and which is the inheritance or the gift.
Right. And what about future earnings? So there's a question asking, can a spouse take claim on the husband's future earnings after divorce?
A bit hard because firstly, you don't know what the future earnings are. So you can't peg something that's speculative.
Right.
So there is a cutoff point, and that cutoff point is at the time of the divorce.
Right.
At the time the court decides, right, the ancillary matters.
Right. And there was a question inquiring, yeah, I found it here. What if the male spouse was evicted and his assets, including his laptop and many things, are withheld? It's not clear by whom it is withheld, probably by the other spouse. How can the law protect him during the divorce and ensure safe return of his stuff?
So in that scenario, that's where, if there are children involved, that's where the mediation will help, right? So these are areas where discussions can be raised, right? It's not so much applying to court to get, because the court process is not necessarily cheap.
Right.
But it's about, okay, did the other spouse keep it? Why did you keep it? Why did you withhold it?
Right.
What was the purpose? And if you're appearing before a mediation judge, it probably doesn't all go well to try and justify why you're keeping your spouse's personal belongings.
Right. Right.
Yeah.
And in context of spousal maintenance and division of assets, we actually do have repeat questions on the validity of prenuptial agreements.
Yes. So the law is a starting point on prenuptial agreements. Prenuptial agreements basically means you sign off on an agreement before the marriage. Right? The law is that the prenuptial agreements do not bind the courts at a time when it comes to the divorce and the division of assets. But the courts will take it into account because it would show and demonstrate what was the intention of the parties. So if you have a prenuptial and during the course of the marriage, if whatever was agreed in prenuptial, they carry on in the same vein, in the same intention, then when it comes to the divorce, certainly one can argue, right, that throughout the entire marriage, the parties were actually keeping to the prenup. But the prenup is really dealing with premarital assets. So during the marriage, you'll have marital assets.
Right.
So marital assets will be divided,
Right.
as a matter of law.
Right.
Right. So in a prenup, you're trying to ring fence your individual assets accumulated
I see.
before the marriage.
Okay.
Yeah.
Okay. And there's an interesting question here. My ex-wife has refused to move out after the divorce, claiming that she has nowhere to go. Can I collect rental from her?
After the divorce, meaning after the case has been sorted out. So, for example, if you had a division of assets already, the court order would deal with how the matrimonial home is going to be dealt with. And usually the options are either you sell in the open market and divide the proceeds, which means eventually everybody will have to move out. Or you have a situation whereby you buy over each other's share and you pay off the other spouse the share that's either agreed or determined by the court. Right? But you have a situation pending the divorce, or if divorce is started and there are obviously tensions, right? And potentially a toxic environment. If that spouse, if the property is jointly owned, you can't quite kick them out because legally they are owners of the property and legally they have a right of occupation.
Right.
So you can't kick them out
Right.
in that sense.
Right.
Yeah.
Right. And speaking of homes, are there any additional considerations when there is an HDB flat involved?
Indeed, there are. It's certainly more complicated than having private property, be it condos or landed property. So HDB, you are governed by the HDB rules and regulations. So sometimes you may have a divorce ongoing, but you've just gotten your HDB flat, be BTO or new flat, right? Direct purchase from HDB. You may not be in a position to sell it because you don't satisfy the minimum occupation period, the MOP as we call it.
Right.
Or you bought a resale, but you're not satisfied the MOP. So those are the considerations right at the start, right? If you see a lawyer or you get legal advice, those are the considerations you would think of as to how to resolve it. Because if you can't sell it and you get to a divorce, the HDB would not permit a postponement of the sale or a postponement of transfer. And you may end up having to surrender the flat back to the HDB.
I see.
And that becomes a financial problem in most cases because you're likely to lose out financially.
I see.
Yeah.
And I know that this is a webinar on marriage and divorce, but there's a question inquiring what are the implications of annulment versus divorce under the Singapore law.
Yes, so annulment is different from divorce. Annulment means it's void. That means if you do succeed with an annulment, it's as though you're not married, right? But annulment is not based on adultery or unreasonable behavior, right? It is based on willful refusal. One of the reasons, and the most common one, will be willful refusal to consummate the marriage. So you have a marriage, but the spouse willfully refuses to consummate the marriage.
Right.
And what that means in terms of the evidence, right, is attempts made by one spouse, the one applying for an annulment, to consummate the marriage, and the rejections, right, made by the other spouse. That's why it's the willful refusal. Yeah.
Right. And there's another interesting question here about the effect of a spouse's bankruptcy on matrimonial assets during divorce.
Yes. So once you are declared a bankrupt, the bankrupt's estate goes into the official assignee's care, so to speak, right? And if there are any litigation proceedings, you need the permission of the official assignee to commence or be part of that litigation.
Right.
So in a bankruptcy, the official assignee obviously will call in the assets. And so it depends on what share that spouse will get. That spouse may not be in a position to just receive everything. It will go to the official assignee, and then the official assignee will look at the distribution between the creditors of the bankrupt spouse.
Right.
Yeah.
Right. So we did not have a formal Q&A session because we have already taken on quite a lot of questions during the course of the webinar. And I don't think we have time to take on more questions. I'd like to invite each of you to leave us with one key takeaway. Ming, would you like to start?
Yeah, I can start first. I think issues do happen and do spiral in relationship within the family or within marriages, right? I think it's to really highlight how there are helps available and how can they also identify the signs of things already being affected. For example, communication breakdown, for example, conflict getting more and more frequent and regular, right? So to also seek help early, not just for the children, but also for themselves, because how does this constant conflict could also be been affecting them as well as, like, for example, there are other aspects of life, right? Like, for example, employment and how they are handling other things that are happening. Yeah, so to seek help as early as possible once they see the sign. I think the other thing to take note is how children see, feel, and experience everything that's happening at home. A lot of the cases that I've seen, the parents are surprised that the children actually knew that the parents are already going through divorce, even though they have not spoken about it formally to the children. So a lot of times the parents bring them in saying that, they want us to process the experience of divorce. But once the topic is opened up, the children themselves actually told the parents that they are aware. They already heard things that are happening in the family. They saw how things have changed in the family. So they do see and experience, even children as young as 1 year old can see the changes that are happening to their parents. We have seen 1 year old child that start to comfort the mother a lot more because the child can see how sad or how sad and how angry the mom is most of the time. So the child feels the need to actually take care of the mother. Yeah, so to also know that that for children, actually, what is important to them is to still have time spent with either of the parent, because both parents are important to them, right? So no child want to lose their father or mother in the process of the parent conflict and issue. So how do we also ensure that children still actually get to spend enough quality time with each of the parent despite the problems that are happening? Yeah.
Thank you very much for that. Teong Liang?
Divorce is very difficult for the parents and for husband and wife. So you can imagine it's going to be incredibly more difficult for the children. My takeaway is that for parties who are going through a divorce, to sort of take a step back and think about your kids. No child asks for their parents to be divorced. Whilst mom and dad may not be able to get along in the marriage, you can't divorce your children, neither can the children divorce the parents, right? And children really need love and security, right? And I think parents should think about that whilst they're going through divorce and put their children at the forefront of everything that they want to try and do, and sort not have that battles, right, which impact the children. Right? Because ultimately, if the children are impacted, if you think about it, they are going to be impacted sometime down the road.
True.
As mom and dad, right?
Yes.
They'll have to pick up the pieces later.
Yeah, very true.
You know, so maybe protect the children. They are innocent in the unfortunate breakdown of the marriage. So just think about that and maybe work things through in the right spirit for the children. Yeah.
Thank you very much, both of you, for those very valuable insights. Unfortunately, we have to bring our session to a close. Our next webinar will be Workplace Rights and Responsibilities, happening on Thursday, 25th September at 7:30 p.m., that is tomorrow. This session will cover key developments, including flexible work arrangements, fair hiring practices under the new workplace fairness legislation, and changes to leave entitlements such as increased paternity and unpaid infant care leave. The session will also address what employees should know about their rights during retrenchments, terminations, and company restructuring. For employers, the speakers will discuss compliance obligations and how to adapt HR practices to meet evolving expectations. Whether you're navigating these changes from a business or employee perspective, this webinar will help you understand the legal shifts and how to respond effectively. As a quick reminder to all of you, this and many webinars are part of the Law Awareness Weeks at CDC 2025. You can click on the link shared in the chat function to visit the website geo.gov.sg/law-cdc to register for the next webinar or the many more webinars available. Also, if you missed any of the webinars and wish to catch the ones you have missed, the recordings of all the Law at CDC webinars will be made available on Pro Bono SG's YouTube channel 2 weeks after the end of the live webinar. You can check out the channel on YouTube. After today's fantastic sharing from our panelists, if you find that you require legal guidance on your legal issue, do write to help@probono.sg. And lastly, we would like to express our gratitude to Teong Liang and Ming for sharing their knowledge and experience with us. With that, on behalf of Pro Bono SG, we would like to thank all of you for joining us today and have a good week ahead.